Let's return to This Week in America. Here's your host, Rick Bratton.
Welcome back, everybody, coast to coast, This Week in America. Frederick J. Fisher's Claims-Made Insurance, the policy that changed the industry, is an indispensable guide for insurance professionals navigating claims-made policies. This comprehensive book explores the evolution and critical aspects of these policies that have transformed the insurance landscape. Frederick Fisher, Juris Doctor, certified claims professional, is a seasoned expert in professional liability with a career spanning over 50 years, including 20 as a claims adjuster and owner of a third-party administrator, renowned for his dedication to client financial security. A founding member and past president of the over 40,000 members strong Professional Liability Underwriting Society Plus, and he was awarded the Plus Founders Award in 2019. In addition to his roles in education and advisory, Frederick is a prolific writer and speaker. Over 80 industry-related articles to his name, along with more than 175 industry-related presentations and classes. President of Fisher Consulting Group, founder of ELM Insurance Brokers. His book, Claims-Made Insurance, the policy that changed the industry, a deep dive, review, and history, has been number 1 in its category on Amazon. It's called an irreplaceable classic. And author Frederick J. Fisher is our guest on This Week in America. Frederick, welcome to the program. Great to have you with us.
Well, thank you, Rick. I appreciate the invitation, and it's really an honor to be here and to be able to chat with your audience.
Well, it's a pleasure to have you here, giving us some great information. And let's start very briefly with claims-made insurance. What are we talking about? Just a basic definition.
Well, a claims-made policy is for businesses, and it's mainly designed for businesses that provide a service to others for which they charge a fee for that service. And that would include architects and engineers, accountants, insurance agents and brokers, and real estate agents and brokers, and lawyers, and medical professionals. It also is a type of policy that is used for corporate coverages, what that are commonly referred to as C-suite coverages for the the corporate suite.
Yes.
Of the officers and the corporate officers and corporate directors, and those policies are written on what's called a claims-made basis, which is different from the type of policies that most of the people that are listening in are used to, because when you're thinking about liability insurance or protection for when somebody might sue you for some reason, most of those policies are written out on an occurrence basis, like your auto insurance, your homeowner policy, your general liability policy to cover slip and falls and what have you for your businesses, workers' comp, etc. Those are all written on an occurrence basis, which means that the accident has to take place during the policy term. So it's like when you run a red light and you accidentally hit a pedestrian or you hit another car, and you're thinking, oh, thank goodness my policy just renewed. I'm covered. I don't have to worry about it, so to speak. And that's because the accident took place during the policy term. And there's a very good reason for that, because usually the injury to a third person is almost immediate. They may not know how serious it is. That may take time to determine. But at least the accident takes place during the policy term. The person's immediately injured. They know they've been injured. And so now that starts the clock ticking for them if they want to hire a lawyer and file a lawsuit on time. Usually the statute of limitations could be 1 year or 2 years, and in some instances a little bit longer. But when a professional commits a wrongful act or an error, when they make a mistake, unlike running the red light, if they make a mistake, that doesn't mean the person's been injured immediately. That doesn't mean the affected person even knows they've been injured.
Yes.
And a good example of that is maybe your insurance broker forgot to increase your limit of liability or increase your fire limit on your home or your condo. Or maybe they didn't renew the policy at all, even though they got the instructions to do so. And so now you don't know that your policy hasn't been renewed. And then when you finally find out, well, have you had an uninsured loss? just because he failed to renew your auto insurance, have you had an accident? Was your car stolen? And if the answer is no, you haven't been injured yet, technically.
Yes.
And sometimes an error could take a long time. For instance, like an architect, maybe they messed up on the load factor on a pedestrian bridge over a major thoroughfare, whether it be a highway or just a major boulevard, or even going from the central parking lot at the airport to the terminal. They're using a pedestrian bridge, and maybe the load factor isn't right, but nobody's going to know until the cracks start appearing, and maybe, God forbid, it collapses. Now that could be in 6 months, that could be in 6 years, that could be in 20 years. So the problem with claims-made policies is that, technically speaking, unlike an occurrence policy that has a long tail, because an occurrence can take place, but it may take a long time to develop, or anybody to make claims under it, that meant that you had to keep all your insurance policies in your drawer for forever, in case you have an occurrence that dates back to the 1990s. The same would be true of lawyers and what have you. When policies like that were written on an occurrence basis, they had to keep all their policies and their files. Can you imagine the kind of warehouse that might take to store 30 years worth of files and policy forms? How about architects and engineers? Same problem. And from an actuarial standpoint, how do you deal with that when you've got such what they call a long future tail? So in essence, actuaries just picked an arbitrary date of 5 years. They close the books after 5 years. They figure there aren't going to be any more claims coming in to trigger an occurrence policy after 5 years. That's not always correct. So to achieve some sort of actuarial certainty, in 1964, a fellow named Joe D'Alessandro dreamed up the idea of making the trigger of the policy when a claim is first made against the policyholder. Now that's interesting, because now all the power is in the claimant. They get to choose when they're going to make the claim. The policyholder has no control over that. Nonetheless, what it gave was actuarial certainty, because now when you have a 1-year policy that you have to renew, if there have been no claims made against the policyholder at the end of that year, in theory, you could close the books on it, which made it easier for actuaries to know what the experience has been on a book of business and how to deal with it from a pricing standpoint and an adjustment standpoint and what have you. That was the theory. And it in a way, it works. Even in the 1970s, for instance, lawyer professional policies, you had your choice. You could buy a claims-made policy, or you could buy an occurrence policy. Which one do you think was cheaper?
Yes.
The claims-made.
Yep.
Claims-made policy, because the occurrence policy is going to have a long future tail.
Yes.
Claims-made policy doesn't. That was the theory. Didn't exactly work out that way, but still, it still gives the actuaries a better handle on how to review a book of business and its performance. And for other reasons, that's not so true. But I don't know if we'll get into that. But that was in essence what happened. Well, back then in the 1970s, nobody was defining. None of the policies defined what a claim was. So they had to use the common law definition, which was a demand for money or services. And that was something that came about through court decisions. The courts decided, we'll define what a claim is, since a policy doesn't. Well, that changed by the 1980s. More and more you started seeing policies that would define the word claim, and there was no consistency at all. Everybody had a different idea, or what they thought was a better idea, on how to define the word claim.
Yes.
And it created a whole myriad of other problems, which is when I wrote my first article about it in 1990, discussing all the problems that are taking place, because the policy originally didn't define the word claim. So the courts universally adopted a demand for money or services. And then all of a sudden you started getting all these other crazy definitions. And the theory was you're only supposed to have one policy respond to a claim under a claims-made policy. But because of all these crazy definitions flying around, there was even a case that I cited in my 1990 article where 3 different policies covered the loss, and that's not supposed to happen. So, hoist it on your own petard, so to speak.
Yes. Well,
and then it got more complicated after that. I've written several articles over the years that have been published by major insurance-related organizations on the dangers of a particular segment of the claims made policy, whether it was the claims made triggers or extended reporting provisions and a lot of other complexities and problems. And ultimately, it decided, you know what, I'm going to take all these articles and just do a book that covers it all. And so that's how the book came about.
You've done that. I would say you've done that. You've done that so well, and #1 in Amazon in its category, receiving rave reviews. The book is "Claims Made Insurance: The Policy That Changed the Industry: A Deep Dive, Review, and History." The author, Frederick Fisher, our guest on the program. His website, fishercg.com. Book is available, of course, wherever books are sold. I'm reading the number of preventable claim denials is increasing. Why is that?
There are several reasons. #1, inconsistency in the policy language. People take this stuff for granted. Oh, I've got my policy, I'm covered. They don't realize what they have to do. And then the other problem with claims made policies is, what if you know you made a mistake, but your client doesn't? Maybe you think you can even fix it before your client finds out there's even a problem, and that way you can avert any problem at all. Well, as soon as you start thinking that I need to fix a problem, no claim's been made against you yet, so technically the policy hasn't been triggered on that basis. But there is, and this has existed since at least 1972, there is this what's called an incident reporting provision. It's what I call the safety net. You know you've made a mistake. You know you're not sure whether you can fix it and avoid a claim, but you know you made a mistake. At that point, there's a provision in the policy that would allow you to report that incident to the insurance company. And yes, you got to tell them who might be affected, how much damages might be alleged, what the error was allegedly, even though you don't want to admit you made one. But if you give them what's required, those 4 items, and some of them may have 5, if you give them that, it triggers the policy. So that even after the policy expires, if later the party that is injured makes a formal claim against the policyholder, that policy will respond even though it's already expired because of the safety net. So to answer your question, what's happening is people are making mistakes, or they make a decision that they know is wrong. Maybe the board of directors have decided, no, we're not going to be extra careful with the handling of our nuclear waste. We'll just dump it. Well, right then and there, you know you've made an error in the judgment. You know there's probably going to be a claim made against you in the future. That's obvious. But sometimes it's not so obvious. And in addition, the point is, remember, when the policy expires, that's supposed to be the end of it, right?
Yes.
So what's happening is, #1, they're not using the safety net procedure. #2, they're hoping to fix it. #3, when they sign a renewal application, because you have to renew these policies every year, and you've got to sign a renewal application with a warranty that says, I am not aware of any fact or circumstance that could give rise to a claim, and yet you do. You are. That's fraud. That's misrepresentation. So what happens is you're trying to fix a problem, you can't fix it. A year later, the claimant who was injured finally makes a formal claim against you. The insurance company investigates and find out, oh, you knew about this before this policy incepted. You didn't disclose it. You didn't, tell the truth on your application. And on top of it, you didn't even report it as an incident in the prior policy year. We're denying coverage. And they're winning.
Oh, yes.
They're winning. And they're accurate. It's absolutely true. That's where you have to really realize, take this stuff seriously. In 2023, I wrote a rather large article that was published by the International Risk Management Institute. Looked at 224 claim denials throughout the United States. Every single denial I agreed with. And they fell into one of 5 categories. Either you didn't disclose on an application, you didn't report the claim on time like you're supposed to, because now claims have to be first made against you and be reported to the company during the policy term. You didn't, do what you're required to do, or, it's related to a prior claim, or the claim arises out of a wrongful act that is prior to some other date limitation called a prior act date, and what have you. And all these claims are being denied, and rightfully so. What's interesting about that statistic, however, and since that article came out, there's been 50 more 50 more denials. And what's happening is interesting because the statistics we came up with, well, I broke it down by type of denial, why is it being denied, or what type of professional is being denied. And the single largest group of professionals who were giving rise to these denials were not architects, were not insurance agents, were not doctors, they were real estate brokers, they were lawyers, and most of them litigators. You'd think they'd know better.
Yes, you would.
And yet, either they got an ego problem, I don't want to admit an error. We can fix it. Well, as soon as you start talking about we can fix it, that's when you use the safety net and report it, but they didn't. And then they lie on their application saying, oh, we're not aware of anything. It's boom.
And that's the lawyer who's doing that. It's the lawyer who is doing that. I wouldn't have guessed in that category would be number one.
Number one, 24. I think it was 26% of all of the 224 denials were from law firms. The second largest category, however, was equally interesting, and that was directors and officers running into the same problem. But it made perfect sense, because what does a director and officer of a corporation do when they get served with a lawsuit? They turn it over to corporate counsel.
Yes.
And corporate counsel may or may not say, do you have D&O insurance? Do you have director and officer insurance? Do we have employment practice insurance? Do we have fiduciary liability insurance? They don't ask that. And by the time they do, it's probably too late. So that's another reason why all these claims are being denied. Directors and officers represented 22% of all claims being denied. So between directors and officers and lawyers, there's 46% right there. All of 224 denials, 46% were lawyers or directors and officers.
Almost half in those two categories. Is there any standardization, uniformity between states?
No, nor is there uniformity with respect to policy language as well. There are so many of them out there, and they're all slightly different in one shape, form, or another, and that's another problem. But here's where the real problem as well comes about. Your insurance broker in 37 states is not required to give you any advice. It's referred to as the order taker standard of care, which means you tell your insurance broker what you want, what you think you need, and their job is to get it.
Yes.
Or if they can't, they have to tell you that. Other than that, they have no duty to advise you at all. Now, there are exceptions. If they hold themselves out as an expert, if they agree to do what's called a risk management fee, preferably for an additional fee that you pay, in addition to the commission they get from the insurance company, or they misrepresent coverage, then they can be held to a higher standard of care. But absent that, they have no more obligation to provide you any advice than your server at your favorite restaurant.
It's just
things like that. Isn't that crazy?
That's amazing. And I'm reading too that claims now are being stalled, and that results in, it takes longer, results in more money. Why is the stalling occurring is what I'm trying to ask. Is that something planned, or is that slowness in the courts? What's the problem?
Profit.
Okay.
They think they're going to make more money by delay, deny, and defend. And they think they can wear you down to accept less. And I've seen that happen. I was an expert in a case where even the trial judge was, really upset because the defense lawyer had estimated 7 days for trial. And then he turned around and did everything he could to stall and delay trial. Long questions, long pauses between questions. I testified on behalf of the plaintiff. So the plaintiff was still putting on their case. The defense hadn't even started yet. And that was day 21 of the trial.
Wow.
Ultimately, he got what he wanted. He got a mistrial because too many jurors were raising their hands saying, I can't be here any longer. And they were filling out hardship requests. And when they got down to 10 jurors after going through the alternates, the attorney responsible for all this refused to stipulate to going to trial with 10 jurors instead of 12. So the judge had no choice but to declare a mistrial. And at that point, the plaintiffs in this case, who had a dead bang winner of a case, decided to settle. They just didn't want to go through another trial. So it worked. Now, does it always work? No. And sometimes it backfires. You get these nuclear verdicts, huge verdicts,
Yes.
multi-million-dollar verdicts. And then the defendant goes whining off, oh, this is so unfair. Look at how the nuclear verdict is terrible, blah, 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 blah. Of course, they failed to tell you that they had plenty of opportunity to settle and didn't.
Yes.
Or in some instances, never even made an offer. They're hoping to get legislative changes. We've already seen, in my estimation, we've already seen the courts go ultra-conservative, and a lot of things we used to think about in the insurance industry have gone out the window, such as insurance being a contract of adhesion, meaning there's an unfair bargaining position between the insurance company, its policy, and your ability to negotiate the language. It's take it or leave it, but that's out the window now if the language is, quote-unquote, clear and unambiguous. The same is true of a lot of other maxims that I grew up with in the insurance industry, such as the insuring agreement, what you're covered for, is to be broadly interpreted and exclusions narrowly construed. That's out the window. And in fact, in the Sixth Circuit, they were making a decision about what I call an absolute exclusion, which are very broad. And the court said, we're about to enforce a staggeringly broad exclusion. They used that phrase, staggeringly broad exclusion. More and more insurance policies are being intentionally written so that the insurance company can pay you even less and for less hazards. And the courts are ruling the policy's not illusory if only one type of claim is covered. Think about that. Usually, if you're an attorney, you're an architect, you've got so many different hazards and perils you are normally covered for, and that's being intentionally narrowed.
It's amazing.
Lawyers are actually writing articles on how you should hire knowledgeable coverage counsel to help you draft policy language so as to be able to avoid claims that normally would be paid. Couple that with the order taker standard of care, you can't rely on your insurance broker. And I'll give you, it's easier to tell you the 13 states that don't follow the order taker standard of rule. Those are Arizona, Connecticut, Florida, Georgia, Hawaii, Idaho, Michigan, Montana, New Jersey, Pennsylvania, Virginia, Washington, D.C., and West Virginia. They do not follow the order taker standard of care. And of those, two, Florida and New Jersey, hold insurance producers, like your agent or broker, to a fiduciary standard of care. Florida by case law, and in New Jersey codified it. So that's it. That's crazy.
Yes. Just trying to sort all of that out. It's amazing what's out there. The complexity of this, you would think over the years, maybe it would be reduced to something that was manageable. I've got just a few minutes left in the program. I want to talk about what consumers need to do. Are they paying enough attention or just totally relying on their insurance broker to put together what he feels, she feels is necessary for you? What should the consumer do?
Number one, you can't rely on your insurance producer, especially if you're in one of the 37 order taker states.
Yes.
And even if you are lucky enough to be in the other one of the other 13, you still have to be a little more specific. You cannot tell your insurance broker, I want to be covered for everything. That's too broad and too vague. Number two, I don't know any insurance broker, and even I won't do, or wouldn't do it, to recommend limits. Because then you're just dead. Because there's always going to be a loss that's going to be worse.
Yes.
And I've seen that happen. You can't do that. What you can do is get some alternative quotes, and here's a liability limit for $1 million. Here's $5 million, $10 million, $20 million, and then you can make a decision on what you feel you need and what you can afford. But, you've got to set the standard. You got to tell your insurance producer, I expect you to tell me what I need to know about this policy. Take the time to sit down with them. Don't just assume, I've got a policy, I'm covered. And don't buy into buying on price. Never buy on price. And here's why. You're programmed. You see the advertising every day. Oh, I just saved $400 on my auto insurance. Oh,
yes.
I just saved $500 on my homeowner insurance. And you feel so good. And what you don't know is you've given something up. No two policies are alike. And a homeowner policy from company A is not the same necessarily as from another company B. Don't think that they are. That's number one. Number two, what are you giving up? And don't forget the placebo effect. Once you've saved $500 on your homeowner policy, John's going to come over and deliver your policy. Don't you feel good? You've saved $500 on your policy? That's placebo. Now you feel really great. Until you find out your claim is under your insured, or you don't have the right coverage, or you gave up something, so something that should have been covered is not, and you're going to blame your insurance producer? Good luck with that.
Yes. Or they raise the rates the next time. Once you have a claim, then suddenly you're uninsurable.
You put it in writing, I want you to sit down with me and go over things. Number 2, authorize in writing your insurance broker or agent to use the services of an intermediary if necessary. An intermediary really is a wholesale broker. You'd be surprised how often a wholesale broker is involved. Your broker or your agent, he's at the retail level. He's dealing directly with you, the consumer. But he may go to a wholesale broker to access markets he can't get to, or to access markets that require extra expertise. Your personal lines insurance agent probably doesn't know anything about professional liability, but you've asked him to get a professional liability policy. Well, so he's going to get one that's cheap. He's not going to sit down and explain it to you. He's not going to go over the claim made trigger language. He's not going to do that. He's not required to. And so you're going to think you're covered when in fact you're not.
Well,
and I can tell you right now, these policies are being intentionally written to narrow the scope of coverage, and you're seeing it every single day.
It's a fascinating topic and good advice for all of us at the end to ask questions and get things in writing. And this is why Fred's book is number 1 in its category on Amazon. Our guest on the program has been Frederick J. Fisher. The book is Claims Made Insurance, the policy that changed the industry, a deep dive, review, and history. Boy, we've just touched the surface of this. There's so much there to talk about, all covered in Frederick's book. Thank you so much for being with us on the program. Great stories, great advice. It's why you do so well in writing your stories, the columns, and writing the books. And they do so well. You break this down where it's understandable by people in the industry and people from the outside looking in to see what they should be following. It's been a pleasure, Frederick. Thank you so much for being with us on the program.
Thank you for having me, Rick, and I hope you'll have me back again.
There's so much to talk about. I got 14 more pages of questions here, so we'll definitely do that again. Frederick Fisher is our guest. His website, fishercg.com. I want to thank christianworksmedia.com for arranging a conversation today. Dream big and succeed with christianworksmedia.com. Information on Frederick, and of course, a link to his website on our website, thisweekinamerica.us. You're listening to This Week in America, and we're back on today's program right after these messages.
This Week in America is online. You can visit our website, thisweekinamerica.us. Scott Pinkerton, associate producer of This Week in America. Jay Anderson, segment producer. Ben Watson, webmaster. Otto Bechet, director of engineering and TV production. This Week in America produced and is a trademark of Blue Funk Broadcasting, LLC. For information on all of our guests and to listen to this week's show, our website again at thisweekinamerica.us. And I'm Sean Bratton, executive producer of This Week in America.